As October 1st draws closer and closer, the Nigerian government, I think their strategy is to use the End SARS protesters, that is, those who were arrested during the End Bad Governance, pardon me, not End SARS, the End Bad Governance protests. They are using them to serve as a scapegoat or as an example to those who would want to go out on October 1st to protest. It's very obvious because the government is adamant to treat these people as terrorists. They're adamant, to treat these people not just protesters, but people who destroyed government property and is against the government one way or the other. Anyway, the federal government has rearranged 10 end bad governance protesters on amended charge. We're going to take a look at the amended charges in a bit, but before we do that, if this is your first time here or you haven't subscribed to this channel, please go ahead and subscribe, like this video, leave your opinions in the comment section. Help us like our videos, so thank you very much. This is the only way that YouTube can promote this video to other YouTube viewers all around the world. Mr. Marshall argued that the charge was not in line with Section 216 of Administration of Criminal Justice Act 2015. The federal government on Friday rearranged 10 persons arrested in connection with End Bad Governance protests organized between August 1 and August 10 on alleged treasonable felony. Imagine people who are just outside protesting, they are charging them with treasonable felony. The federal government, through the Inspector General of Police, Kayode Egbetokun, rearranged them on 8-count amended charge following an application by the prosecution counsel, Simon Long San, before Justice Emeka Nwete of Federal High Court in Abuja. The 10 protesters were arrested in Abuja, Kaduna, Kano, Katsina, Sokoto, and Gombe states over the 10-day protests, which resulted in violence and killings in parts of the country. The 10 protesters were arraigned on September 2nd before Justice Nwete on a 6-count charge. They, however, pleaded not guilty to the charge preferred against them. The judge admitted them to 10 million naira bail each on September 11 with one surety in like sum. Upon resumed hearing on Friday, Mr. Long, in his application, sought to substitute the earlier charge with the amended one, which included Daniel Akande as 11th defendant. Mr. Akande, a member of the Solidarity Network for Workers' Rights, was arrested on September 1 in Abuja during a church service. After the fresh counts were read to the defendants, they pleaded not guilty to the charge. Mr. Akande, 11 defendants' lawyer, Deji Adeyanju, prayed the court to admit his client to bail on liberal terms, while other defendants' lawyers urged the court to allow their clients to continue with earlier bail granted them. The judge agreed with Mr. Adeyanju and admitted Mr. Akande to 10 million naira bail with one surety in like sum. He also held that the defendant must submit his passport to the court registry. He said the surety must swear to an affidavit of means and must reside within the jurisdiction of a court. Justice Nwete also granted the prayers of other defense counsel. Earlier, counsel to the first and second defendant, Abubakar Marshall, opposed the application by Lang for the amended charge to be read to the defendant. Mr. Marshall argued that the charge was not in line with Section 216 of Administration of Criminal Justice Act 2015. He submitted that the prosecution cannot, on unilaterally amend the charge without the leave and permission of a court. He also told the court that the prosecution had not served the parties with a proof of evidence which the defendants could rely on. He said in the course of previous proceedings, they did apply and emphasize the need for the prosecution to furnish them with a proof of evidence to enable the defendants prepare for their trial. Mr. Marshall further stated that the prosecution must furnish them with a list of every witness they intend to rely on. He said the written testimonies of all witnesses and all the documents must be provided. Any procedure contrary to this invalidates the entire procedure. The lawyer also hinted at the application pending before the court, seeking variation of bail for 3rd, 4th, and 10th defendants, respectively, in line with Section 396 of ACJA. He informed the court that they had been able to perfect the bail conditions for 7 out of the 10 defendants. He therefore prayed the court to vary the bail terms for the remaining 3 defendants in the interest of justice. Lawyer to the 4th defendant, Anthony Itejere, aligned with Mr. Marshall's arguments, but Mr. Long disagreed with them. The senior lawyer argued that there was no specific mode on how an application for amendment of charge can be moved. On the service of a proof of evidence, he said investigation is a continued process until judgment is delivered. He argued that the ACJA made provision for additional proof of evidence and would be served on the parties involved in the case. He said there was no provision in the ACJA that regulates criminal proceedings to include other defendants who are at large in the charge. Justice Nwete, after listening to submissions of the parties, gave the prosecution go-ahead to read the amended charge to the defendants for them to take their plea. He also urged the defendants' counsel to raise their objections if there were any defects at the appropriate time. The matter was adjourned until October 4 for ruling on the bail variation for 3rd, 4th, and 10th defendants and fixed November 11 for trial. Thank you very much for always listening and watching. I will see you all in my next video. Bye for now.